Thank you for joining us today. My name is Sarah Smith. I'm here with Per Oscarsson, and we are here to discuss intestate distributions. What happens if you don't have a valid will or trust set up? So intestacy rules basically determine what the inheritance rights are to property. And this is done looking at the familial relationships between the decedent and their family. The idea being, if we don't have a will or something else that clearly indicates what a person would have wanted, what do we assume that they would? Presumably, they'll take care of their spouse, their children, etc. So these intestacy rules control the part of the decedent's estate where there's a failure of the will. Either there's no will, or perhaps it was drafted improperly. It might be that this is a very old will and there's no one who is designated under the will that is currently living, or perhaps the decedent got married or had children after that old will was executed. And we want to make sure that those people are taken care of. As I mentioned, it doesn't cover everything, so I'll take a moment to discuss what these rules do cover. The decedent has to be a resident of Washington to be covered under these laws. And not only that, it doesn't cover all of those assets. It only covers probate assets. That is assets which are in the decedent's name, which don't transfer by a beneficiary designation, such as a life insurance policy might, joint tenancy with right of survivorship, such as a home might, or really any other mechanism by which you would automatically transfer property upon the death of the decedent. So examples of this might be bank accounts, vehicles, solely owned real estate, business interests, things that would require probate to transfer that title and that ownership. And in addition, speaking of real estate, while the intestacy laws would cover all probate assets, the control of the transfer is controlled by the state. So real estate that is in Washington will be covered by Washington's rules, but real estate that might be in Arizona or Oregon or where have you, that will be covered by the rules and controlled by the rules of those states. So if you do own property there, that's something to be aware of, and another reason to make sure that you are being proactive in your estate planning. So we figured out the assets. What happens to them? Well, it really is an idea of what would an average person want, do we assume? Clearly, it's not one size fits all, but we're going to do the best that we can. And what the codes do is they look at two things. Is the property community property owned between the decedent and their surviving spouse or domestic partner, or is it their sole property? Perhaps they're not married at all. Community property will vest solely in the surviving spouse. This is what they've earned together. This is what they've made together. We want it to go to that spouse to take care of them. The separate property, that has a bit of variation. If the decedent had children and was married, then half of that separate property goes directly to the children. If there are no children, then 75% would go to the surviving spouse and 25% would go to the parents, or if no parents, to the decedent's siblings. The idea being that we would want to give care for these people. And if there is no domestic partner or surviving spouse, then all to the children, if not to the parents, and if not to the siblings. And it's worth noting that while we're talking about kids, it's not just biological children. It also includes adopted children. And that is important because it also means that those adopted children inherit from their adopted parents, not from their biological parents. On the other hand, stepchildren typically do not inherit under intestacy laws, which is again where we go back to the importance of having this will drafted, is to make sure that your specific desires are respected. because otherwise things might not go quite the way that you intend. Um, and I know Harry is going to be discussing the administrative side a bit.
And the administration doesn't differ that much from administration when a will is involved. Of course, with a will, you can nominate your personal representative, but if there is no will, then who has the right to serve in that capacity? And the statute sets out a priority list, which is, if married, a surviving spouse, if not married, a state registered domestic partner. And if there is neither of those, then it goes to next of kin in the order of a child or children, parents of the deceased, siblings of the deceased, grandchildren, and then maybe nieces and nephews. And if there's more, we'll go with the first part of that with children. If there's more than one, they all have the right to serve. Typically, that may not be the best circumstance, best set of facts. It may be best to have one serve, in which case the other children would have to decline to serve, and then the remaining child would be the petitioner to start the administration of the estate. Like I said at the beginning, there's not much difference in the administration and getting the administration of an intestate estate started than there would be if there was a probate of a will. The forms are slightly different just because there's no will to refer to. But otherwise, the whole process of the petition to get the probate started, the information that's required, again, is very similar to what's required when you're probating a will. You'd still need to show that the estate is solvent, that the value of the assets exceeds the expected amount of debt, because that can be very important, as it is with probate of a will, that the personal representative usually will not receive non-intervention powers if the estate is not solvent. Non-intervention powers meaning that the personal representative does not need to go to court to get approval to take action. They can act without court approval, and then the court only gets involved if there is a dispute. And then we get some potential distribution issues. As Sarah mentioned, one of the things is stepchildren typically do not inherit in an intestate estate. There are very limited circumstances under which they might, but they are very limited, and I won't go into detail on those at this point, just because it happens, I think, so infrequently. You've got people in a committed, intimate relationship where they are not in a state-registered domestic partnership, but they're in a committed, intimate relationship. That is not treated the same as if the two people were either married or in a state-registered domestic partnership. The court will, however, look at the nature of that committed, intimate relationship, and we'll look at things like, well, do they have a joint bank account? Do they jointly own property? How long have they been together? And in that case, then the surviving person may have a claim to some portion of the estate, at least the estate that may have been created after the committed, intimate relationship began. Usually, they do not have any kind of a claim to any portion of the other person's property that other person had prior to the beginning of the committed, intimate relationship. Another thing is blended families. Because there is no will or trust, then if families are blended and there may be children of both spouses or both state-registered domestic partners, if there's no will or trust, then there is no guarantee that the children of either of them would be included in any kind of a distribution. Certainly the birth children or adopted children of the deceased would be covered by the intestacy statute. But the children of the surviving person in that blended family, whether it be surviving spouse or surviving state registered domestic partner, they would not be involved in receiving anything under the intestacy statutes. So I think all of it really goes to how do you want to kind of retain some control over what happens upon your death? Because again, there's no distribution to a charity that you may have contributed to for years or decades, and you may have wanted upon your death that charity or more than one receive some portion of your assets. If you have not provided in a will or a trust for that to happen, it will not happen. I guess there is a caveat to that. Those who will receive, family in that case, might enter into a TEDRA agreement where they agree to some portion of the estate being distributed to a charity. I think that's also unusual, but the statute seems to be broad enough to allow for that possibility. So I guess kind of my final thought on it is, if you want to retain as much control as you can, and that's not to say that you have absolute control, because there may be certain things that even though you express it in your will, it may not be permitted. For example, you may have selected an individual to serve as your personal representative. When the time comes, they may not qualify. And in that case, your estate will then get the alternate personal representative if one has been named. And if one has not been named, then you have no idea who might be appointed, but there may be several people that might qualify. Again, with your assets and how you want them distributed, having it in the will or the trust, or both, depending upon the circumstances of the assets, gives you more of that control. Ultimately, you don't get absolute control, as I said, because there may be some things that you want to have happen that the law does not allow for. So to the extent you want to have more control than what little you would have in an intestate situation, it's a great reminder that doing a will and or a trust, if appropriate, would be a great way for you to retain that control. Sarah?
I think you got it.
And I don't see that we have any questions.
No.
No, I don't think so.
Well, thank you all for joining us, and hopefully you found this helpful. Until next time, thank you so much.
Thank you.